It's a short list of things that can have as big an impact on a household's finances as divorce. When couples divorce, incomes are divided and therefore less, so are assets, taxes might go up, and what was once one set of household expenses now becomes two. So if you or someone you know is beginning a divorce, a good place to start in understanding the impact the divorce will have on your financial life is knowing exactly what you own and what you and your spouse own together, or what is marital property. Stay tuned. Finances and divorce. What is marital property? Coming up. It's Jeff Drayton, Certified Financial Planner Professional, Certified Divorce Financial Analyst, and founder of Jeffrey A. Drayton Financial Planning and Wealth Management, LLC. If you're watching this on YouTube, go ahead and subscribe. And if you're viewing this from the blog page of my website, fill out the contact form at the top of the page so that we can contact you when new content becomes available. Before I even get started, there are a few things that I say at the very end of each of my videos that in this video I'm going to bring right to the front. And the first is, nothing in this video is meant to be specific advice for you. The details of the topic that I'm about to discuss are both subject to where you live and highly dependent on the exact specifics of your situation. Furthermore, nothing in this video is legal advice. I am not a lawyer, and I would highly recommend that if you or someone you know is going through a divorce, you seek the counsel of a qualified family law attorney in your area. However, what I am going to talk about are some principles that are generally true in determining what may or may not be marital property among spouses. At least it will be a starting point. And this is a topic that is relevant for every married couple's financial planning. Knowing what assets you own can affect such things as estate planning or ensuring that property passes to the intended heir of that asset's owner. Failing to take care that your solely owned property maintains its non-marital status can have implications that go even beyond divorce. So to start with, what likely is marital property? Well, with some exception, marital property is that which is acquired from the point that couples are married onward. Generally, any income, property, or savings that is acquired when two people are married is owned by both spouses. It is their marital property. Different states have different rules as to how such things as titling can affect marital property, with the biggest divide being between those that are common law states versus community property states. This is one reason questions about your situation or a specific piece of property that you own are best answered by an attorney in your area. However, again as a starting point, I would assume that if it was acquired during the marriage, it is owned by both you and your spouse. An exception to that statement is property that is generally acquired by gift or inheritance. Assuming the gift or inheritance was made to just one spouse, not the couple, that asset will be, at least initially, a non-marital asset. Additionally, any assets that were acquired prior to the marriage by either spouse will likely also be regarded as non-marital property. So when you have a non-marital asset, either something you owned prior to your marriage or a gift or inheritance that you received during marriage, does that guarantee that asset will forever remain your sole property throughout your lifetime? Well, not necessarily. This is where you're going to want to practice some due diligence in your financial planning, especially if you want that asset to maintain its non-marital status going forward. First off, I would keep careful records that document how that asset came into your possession and ever after track its life as your piece of property. Never let those records go. They are the provenance that will show that this has been and therefore ever shall be yours. Additionally, whenever possible, I would keep that non-marital asset segregated from other marital property that you own. You are free to have as many accounts as you would like, and this includes IRAs, Roth IRAs, and brokerage accounts. There are many good reasons why we financial planners encourage clients to consolidate their accounts. However, this is not one of them. If you have a brokerage account that is holding marital assets, I would recommend you get a different account for your non-marital holdings. Let me give you an example. Say you inherit an IRA from a parent. IRAs as an inheritance from someone other than your spouse will force you to take required minimum distributions from that account. These IRAs have different rules than your own IRA and will require these distributions regardless of your age. Now that beneficiary IRA inherited by you will generally be a non-marital asset. It will only be in your name. If you want it to remain as such, it would behoove you to have those distributions go into a brokerage account that is also only in your name, contains no marital assets, and you will want to keep a record of the transactions showing that clear path of those funds. In some situations, it isn't possible to keep non-marital assets segregated from the assets that you own together with your spouse. Examples might be a retirement account that you have at work, such as a 401k or pension plan, or maybe you have a piece of titled property like a home on which you had a mortgage prior to your marriage that you are continuing to make payments on after you are married. In cases such as this, these assets will likely have both a marital and a non-marital component. It will therefore require some bit of math on the part of your attorney or financial professional to determine the amounts of each at the time of your divorce. Here again, it would behoove you to have kept good records showing what the values of those assets were at the time of your marriage. As I said earlier, if you are going through a divorce or you know someone who is, I would highly recommend that you seek the counsel of a qualified family law attorney in your area. Furthermore, because the financial aspects of divorce can be so impactful and will affect the lives of both parties long after the dust of their divorce is settled, I would also encourage you to seek the advice of a qualified financial professional. Two designations I would look for following his or her name would be the letters CDFA with registered trademark, which stands for Certified Divorce Financial Analyst, and CFP or Certified Financial Planner, also with the registered trademark sign. These designations signify different things, but ideally, I would look for a professional who has both. I'm Jeff Drayton. Thanks for watching. As always, nothing in this video is meant to be specific advice for you. Advice like that can only be had by working with a financial planner, someone who knows you and your situation. I would encourage you to seek out someone who is a certified financial planner. This is signified by the letter CFP with the registered trademark sign following his or her name. I would also encourage you to work with a fee-only financial planner. Now that's two words, fee-only, not fee-based, not fee plus commission. Both of those terms mean that the planner or advisor can receive commissions and is therefore not free of the conflict of interest inherent to commission sales. Again, I'm Jeff Drayton. Thanks for watching.